Hey guys, this is Navdeep Singh Jirla. Thank you for clicking this thumbnail. Today we are looking at a sponsorship application. This is an appeal made after the refusal to the Immigration Appeal Division, and we'll see what are the characteristics of this application and we'll see what we can learn. Appellant is a person who is currently in Canada, either a Canadian citizen or a permanent resident. Harmandeep Kaur, the applicant. Applicant is a person who is in India. The application was for immigration to Canada as a member of family class as permitted by Immigration and Refugee Protection Act. It was refused because it was captured by the bad faith provision set out in the subsection 4.1 of Immigration IRPR. The reasons are set out in the April 30th of 2018 refusal letter with additional explanation provided in the visa officer's interview notes. These are the issues as you can see right here. In order to succeed in this appeal, the appellant must establish that his marriage to the applicant is genuine and was not entered into primarily for the purpose of acquiring any status or privilege under the Act. So these are two different things which visa officers assess. One is whether the marriage to the applicant is genuine, that's number one. That may have to do with the legal validity of the marriage, for example, with reference to the documentation, the marriage certificate and other necessary documents, and whether it was not entered into primarily for the purpose of acquiring any status. That talks about the intention of the marriage and what was the intention of both the parties when they first met to discuss about the marriage and when actually marriage taking place. This is the decision given by the Immigration Appeal Division. I find that the appellant has established that his marriage with the applicant is genuine and was not entered into primarily for an immigration purpose. The appeal is allowed. Originally the application went to the visa officer and the visa officer refused it. Then the applicant went to Immigration Appeal Division, and now after the assessment of the validity of the decision taken by the officer, the appeal division has allowed the appeal, which means they have supported the genuineness of the marriage and have gone against the visa officer's assessment. Background: the appellant is 27-year-old Canadian citizen of Punjabi descent. He has spent his entire life in Canada and resides with his parents and his sister in Canada. He is currently working as a car salesman, and the applicant in India is 27-year-old Indian national. She has a master's degree in history and has never been employed. Neither of them has been previously married. So they were introduced through a relative of the appellant who is also the best friend of the appellant's mother, and their marriage was arranged between their families after a formal introduction in December 2015. This introduction took place in India the month following the sudden death by cardiac arrest of the appellant's sister. The appellant traveled back to India in January 2017 to marry the applicant after December 2015, but has not returned to India since the wedding. So they first met in December 2015, the marriage happened in January 2017, and since then the applicant never returned back to India. So here is the analysis part. Now you'll see the visa officer will analyze the basic factors to establish whether it's a genuine marriage or not, which may include the compatibility of both the applicants, the family backgrounds, the qualifications, the circumstances in which the marriage was established and first meeting happened, and all these details. So the appellant grew up in Canada and his first language is English, whereas the applicant grew up in India. In complete contrast, has never traveled to the West, and her primary language is Punjabi. The applicant is also better educated than the appellant because she is having master's degree. These perceived incompatibilities were enough to flag the attention of the visa office. The visa office also found it unusual that the marriage would be arranged so soon after the death of appellant's sister, and found it inconsistent with the appellant growing up in the West that he would not communicate with the applicant until after their Roka ceremony in June 2016, which means the applicant first met in December 2015 and Roka ceremony happened in June 2016, and marriage happened approximately after 6-7 months in January 2017. So finally the visa officer drew negative inferences from the appellant not marrying or living with the applicant in his family's native village or visit the applicant after they were married. I find that the appellant has adduced sufficient credible and trustworthy evidence to overcome the visa office's concerns. The appellant has some unique circumstances that account in many of the elements of the development of the relationship and subsequent marriage that differ from how most arranged marriages would develop. Let me remind you, the applicant is suffering from a very unique disease. Because of that, the applicant was not able to communicate oftenly. So I acknowledge that the concerns of the Minister's Council that the appellant and applicant may have entered the marriage with genuine intentions, but that their relationship has not currently developed into one that can properly be considered as a genuine marriage. However, I have determined that these concerns relate more to the quality rather than the applicant's health challenges, rather than a lack of commitment on the part of the applicant and appellant. I accept the testimony that the appellant has less education than the applicant is not such a significant discrepancy as to render them as incompatible couple in their cultural context. I find that the appellant and the applicant are largely compatible. Though there were some inconsistencies in terms of their education, the appellant was raised in Canada and the applicant was in India, but Immigration Appeal Division find the appellant and applicant are largely compatible. They accept that both the family of the appellant and the applicant trusted the matchmaker and were comfortable with each other, and that the appellant and applicant made a suitable match. The applicant inferred that there are difference in education makes less difference in Canada rather than in India, and had little else to say about it because it was not a matter of significant concern. I accept these explanations as credible. I accept the appellant's testimony that his family had already decided to travel back to India in 2015. So to counter the concerns of the officer that how come marriage can be arranged after sudden death of appellant's sister, so the counter argument is they were already in touch for the discussions and already had planned to come to India. I accept the appellant's testimony that his family had already decided to travel back to India in 2015 before his sister's sudden death. Death suddenly happened. By this time, marriage talks were already underway. I find that the appellant was credible in explaining that family decided to go to India as planned in order to spread her sister's ashes, and they later determined to go ahead with meeting the applicant and her family to arrange their marriage. However, the appellant was in early ages of an illness which has subsequently become much more serious, and his sister had just passed away. Given these issues, I do not draw any adverse inference from the marriage arrangements not progressing and the applicant and appellant having very little communication for the next 6 months after meeting in December 15. The appellant agreed to be a party to an arranged marriage despite growing up in Canada. I do not find this to be particularly unusual in his cultural context, and having agreed to getting married in such a context, I find that it is understandable that he and his bride-to-be would not communicate directly until after their Roka ceremony in June 2016, at which point they had their family's blessings to do so. On the other hand, given the appellant didn't grow up in India and has spent little time there over the course of his life, and that his parents and most of his relatives have long since abandoned their native village in India, I do not draw a negative inference from the appellant not marrying or living in his native village. Although the appellant has not returned to India since the marriage, I found that it was credibly established that the appellant's mother and sister have returned to India, and the applicant has forged a strong familial relationship with the appellant's female family members and spends time with them when they are in India. The applicant's attendance at the engagement ceremony of the appellant's sister is a strong indication that she is accepted and perceived by the community at large to be the appellant's wife and part of his family. The main concern with the marriage left after the hearing was the degree to which the marital relationship between the appellant and the applicant had developed over 2 years of marriage. While it was clear that the applicant has a close relationship with the appellant's mother and sister, the appellant and applicant did not establish that they have a degree of intimate knowledge of each other that one might expect from a young couple that has been married for 2 years. However, I have determined ultimately that this development of the relationship is largely due to the applicant's health issues. So it was perceived positively by the appeal division. If you would like to read the entire case, you can just read it. These were the major issues. Conclusion is the appeal was allowed against the validity of visa officer's decision. All these factors are different in every case, but they should reflect the genuineness of the marriage, and they should be in sync with the regulations that visa officers are following. But we have to accept it, every case is different and circumstances are different, hence the documentation will be different. Thank you so much for watching this video. I'll see you in the next video.